Well, good afternoon, everyone. My name's Kendall Smith. I'm with Thomson Reuters. I am a business development manager for our Court Management Solutions group. And this afternoon, our session is talking about court technology in your modernization efforts, and really how, not for the first time, but in a really long time, technology is really stepping into the forefront of solving court modernization challenges. So today's session, the courts as a service, not a building. How technology must be at the forefront of court modernization. Now, if the pandemic and the events of the past year and a half have taught us anything, it's that the way that we're working has changed. It's changed to adapt to new logistical challenges. It's changed to drive productivity. And it's changed to ensure access to justice and fair treatment for all. With these changes comes a responsibility to put in place the plans, processes, technologies that will modernize a court system. It can't just be a quick fix or a temporary approach. So thank you for joining us this afternoon as we share ways to modernize courts beyond just using video, and learn of technologies that can streamline your hearings, whether remote, hybrid, or in person, making for increased productivity, reduction in backlogs, and ensuring fairness and better access to justice for the people. So I'm going to introduce my panel now. We've got a little change to the agenda that was in the app, so thank you for bearing with us as we've changed some players. I am not David Jackson. I'm Kendall Smith. David has been retained in the UK where he lives. He couldn't get flight privileges to come into the US because there's this pandemic still. So we miss him. I think he's joined us remotely. But again, I'm Kendall. More importantly, I'm joined by our two judicial colleagues or judicial partners in this, Judge Jerome Abrams. The Honorable Judge Jerome Abrams is a first district court judge in Minnesota. That's where Thomson Reuters is. He's on the board of directors of the National Center for State Courts. He's also a board member of the American Board of Trial Advocates, a member of the ABA, and the American College of Business Court Judges. He was recognized as the ABOTA Minnesota Chapter Trial Judge of the Year in 2019. Judge Abrams has recently been inducted as an honorary fellow of the American College of Coverage Counsel. Judge Abrams presents nationally and internationally to judges and lawyers on civil justice topics, including online dispute resolution, e-discovery, and complex case management. He's a co-author of a recent publication on complex case litigation published by the ABA, and authors chapters on ESI discovery and insurance coverage for business torts and other publications. Judge Abrams serves as an adjunct faculty for the University of Minnesota and Mitchell Hamline Law Schools. Judge Abrams is a regular contributor to the Judicial Integrity Initiative, United Nations Office on Drugs and Crime. We're also joined by Judge Alan Alvord. Judge Alvord is an administrative law judge with the California Office of Administrative Hearings. California OAH is a central panel administrative hearing agency that conducts hearings, mediations, and settlement conferences in professional and trade licensing, public benefit, public pension, teacher discipline, and special education cases for state and local government agencies and school districts. Judge Alvord was presiding administrative law judge of the Office of Administrative Hearings San Diego office from 2007 to 2013, when he became the General Jurisdiction Division Chief. When the pandemic required stay-at-home orders, he served on OAH's executive leadership team, managing the transition to remote operations. And in mid-2020, he left management and returned to his first love, hearing cases as an administrative law judge. So welcome to our distinguished panel on what today we're going to be talking about technology and how, again, it's stepping into the forefront in solving some really important issues around addressing backlogs, distributing fair and just access to justice, and all of the different ways that technology can really help modernize and make your courtrooms more efficient. So before we really start the full presentation, just by a show of hands, has everyone gone through some sort of implementation of technology as a result of the pandemic? Pretty much 100% of everyone in the room, so there's no surprise there. Again, with the show of hands, did any of you think that those would be short-term solutions that you were implementing at the time? Was there anyone that thought, oh, this is changes I'm going to be making for a long time?
I was hoping not.
You were hoping for the technologies to stick around. Great.
Well,
We locked some people out. We'll let them in.
yeah.
And again, by the show of hands, is there anyone that has found that there hasn't been additional benefit that has come as a result of the technology that's been implemented? Everyone's feeling pretty good, a little iffy on some things. That's good. Well, those are some of the things that we're going to be talking about, because while technology is certainly something that can help you address certain challenges in your modernization efforts, sometimes it's not, a one-size-fits-all. So we're going to talk about what the challenges are, look a little bit to the future, talk about what some of the benefits are that technology provides, and then some lessons learned. And as you leave this session today, maybe some thoughts or some ideas of how you can start to address or implement long-term scalable technology solutions in your own court. So let's talk about the challenges a little bit first, how we really got here. Now, of course, there was a pandemic. We get that. But as Judge Alvord will articulate, there's many courts that even pre-pandemic were thinking about ways to digitize and modernize court operations even before we had COVID-19. So let's talk a little bit about the challenges that are facing modern courts today. Judge Abrams, why don't we hear from you first? What were some of the challenges in Minnesota that you were facing? That's interesting, we'll let go, okay.
Okay, we'll let it go. Well, thanks. I guess that's kind of over this way. So we can digress. We're kind of among friends here and go back a little bit in time, maybe not too far back. But we can kind of think about what we do that is in courts, a stock in trade. I mean, to give you some example of a stock in trade, Lincoln said that a lawyer's time and advice is their stock in trade. For us in courts, what is our stock in trade? It's always two things, always will be two things. Access to justice, and fairness. Fairness involved in the process and how that justice is delivered. And if you want to state it another way, you can call it fairness and access. But it never changes. And we're always trying to optimize the delivery of those two components to the people that we serve. And that's the challenge. And the continuing challenge from COVID, of course, was what do you do when you don't bring people to the places, to the temple, where they're expecting to get this? I mean, goodness, if we go back far enough in history, we can find out, you got the high priest, you got the big stone buildings, the columns, whether they're Doric, Ionic, we're not going to go that far. But my point is that people come to expect something somewhere, and we've changed that entirely by how this is getting delivered to them. And so then the next component of it is, okay, fine. I mean, I don't know where you were for the first couple of months of going from in-person operations to remote operations, but it was sketchy, may not be the way to do it. We found out, I can tell you what car to buy because I've seen so many SUV interiors between then and now, right? I mean, isn't that where we hold court, is in the front seat of somebody's car? I mean, how long did it take for us to think about the fact maybe they shouldn't be driving when they're in court? Or maybe they should go in the other room and put some clothes on when they're in court? Or maybe if you're out on probation, you shouldn't be smoking pot while we're here recording the whole session. Just saying, okay? But we have changed the way that people now come to receive the same service that they used to see as part of that majestic process. And the challenges have been immense, because we now find too that people, and this is kind of where this all comes around. I'm not endorsing any product, but I am endorsing a concept. And the concept is that for us to have this replacement be fair and robust and accepting by the community that we serve, it has got to be every bit the substitute for the procedural and substantive legal requirements that it is replacing. And that's where the challenge lies. So the concept I'm endorsing is that we've got to make sure that what we do now is going to be enough for people to have faith in the process. Because if we don't do that, and by the way, it's not objective faith in the process. For every litigant, we're just talking about this, every time a person comes to court, we think of them as, well, another person that comes to court. But they think of themselves as this is the biggest deal that they've ever had in their whole life for most of them. And if we don't treat it that way, through this substitute process, we're losing them or failing them in a very, very fundamental way. And so this is when you talk about where does the challenge lie. It's not so much that we can't arrange for a substitute, but we have to make sure that substitute is every bit as good as what they had, and people believe it. So maybe I went too far in my response to what your concerns were, but I don't think it's like a, pardon the expression, a Minnesota thing, That's how we talk, by the way. So if you need some help or lessons, I've done this for groups all over the country. I'll give you my email, and if you can't figure out a word or a concept or a local idiom, just send me a note. We'll get you squared away,
Yeah.
But my point, though, ultimately is it's not a Minnesota thing. It truly, it's a universal challenge that we all face.
And it's such a new challenge that's been thwarted into the process. So we were talking earlier that the sanctity of the court experience is sometimes facing the judge in that formal setting. And now we have this technology, and has that changed that experience that I have as I talk to the judge about my case? So the technology has been implemented to help us bridge a gap, but it maybe has introduced some other things to the process that we have to figure out.
And I don't want to go overboard in terms of kind of how you've allocated this presentation, but one of the things we're also finding, and again, we could take a survey in the room, how many people are planning to keep a significant aspect of their court operations on a remote basis in the future? I bet everybody's going to raise their hand, because we now find that whatever it is we're doing now is, again, in a kind of very Midwestern sort of way, good enough. But certainly it's meeting the responsive court. And also, as we start thinking about this strategically, and maybe we'll have a little time to talk about it later, is the people who fund us are also recognizing that this is a means by which they don't have to build these new edifices, these new temples, these new monuments to the system, because this is a reasonably fit alternative. And so long as the people are accepting and it provides results that comport with substantive law, which is the reason why we're doing all this stuff anyway, so long as it does that, I use the word persist. Remote hearing processes will persist for certainly as long as any of us are around, or until we get replaced by artificial intelligence, kind of whichever comes first.
Okay. Judge Alvord, what are some of your perspectives and about the challenges that your court was facing pre-pandemic and now even since pandemic?
Right. So, we went to conferences like this, and I remember in the latter part of 2019, the experts at these conferences were saying, in 5 to 10 years, the rule will be people won't show up at a physical place to conduct a hearing. Showing up at a physical courthouse will be the exception. And we really took that to heart, and we started thinking about how are we going to get there? And we kind of started mapping out some of the technology backbone infrastructure that we would need in order to deliver that sort of thing. And then COVID. And then it became the accelerant, and we just sort of had to speed all that up. But we had already made some preliminary ideas about how we might approach these things. So we were really lucky. We didn't end up with much of a backlog. We continued cases for about, I want to say, a month and a half. We started when COVID first hit. We'd like, okay, all your cases are scheduled. We're pushing them out. But we didn't push them out very far. And we ramped up pretty quickly with the remote procedures and got the cases back on calendar. So we're in pretty good shape now compared with other.
You mentioned backlogs, and
Yep.
so we should probably talk about that a little bit, because the National Center has been so kind to put together a really great report about what just happened. Where was the log jam of these cases, and why did we have this such a huge rise in backlogs? And I love this phrase, justice delayed is justice denied, and I know that your roles, as court administrators, are trying to figure out how to get rid of those log jams. What I found really interesting about this report, though, is that the primary drivers of case processing times are the numbers of continuances per case and the number of hearings per case in combination with the elapsed time between hearings. So at the end of the day, the problem was people were saying, I don't want to come to court today, or I want to have a stay in my proceeding of some sort. Talk about that a little bit.
Well, you know, Kendall, and you just kind of just tweet me on all this. All right, has anybody here ever practiced law as a criminal defense lawyer? I don't know if we have any lawyers, criminal defense lawyers in this room. So what did you sell your clients other than hope and delay? Seriously. Because as a trial judge, that's what I see. Hope and delay are the stock in trade of the criminal defense bar. It's not wrong, but that's what it is. And the existence of this pandemic has so extraordinarily enabled that to go on for a lot of different reasons. I mean, if you're like, for example, I'll just throw something randomly out there, a felon in possession of a firearm, when you get found guilty, should you get found guilty, you're going to prison. Why would you want to speed that up? What's the point? Or we got a pandemic going on. You know, heavens, you're involved in a robbery. Maybe some of the witnesses might get sick and die. It's not wrong thinking. Everybody wants every advantage they can get, but it's not getting them to race to the courthouse. So I can speak from, you know, my experience and that of a lot of others, judges I speak to in other states, is most of the areas of work that we had during the pandemic in state trial courts, we were able to get along with pretty well. I mean, although filings are down, you know, my clearance rate in civil runs 90 to 95%. We get statistics every week on this, but the rate for criminal stuff actually was exceeding at a greater rate, the backlog, than even cases that were filed. Mm-hmm. It's because jails didn't want to receive people for any reason at all. If there was a reason to divert somebody from any in-custody presence, you were being asked to do it, and that wasn't just a local thing, that was a national thing. People who were already in, you know, one facility, nobody wanted to transfer them to another one to face a new charge or in a different location. So there was just stasis for a lot of different reasons. But rock bottom, it's human nature. I mean, if something bad's going to happen, put it off as long as you can.
No one wants to be in court.
Yeah.
So how do you figure out how to support the process by still giving everybody access to justice? 'Cause at the end of the day, we don't want to be in court. It's just not what you wake up every day wanting to do. So let's talk a little bit more then about you know, some of the other challenges that are happening, and we touched upon this already a little bit. But the trust factor and the sanctity of the court experience, a lot of that comes down to, do I feel like the court system is able to accurately depict where I am in my case timeline? Do I feel like I've been able to articulate to the judge my position on a case? So all of these little case management kind of elements that start to come together are really tied to the technology that the court is using. And often at Thomson Reuters, we hear that customers are concerned about the technology that their courts are using. And I think that this cartoon is a really good depiction on that. How can I trust you, court administrator or judge or clerk, if you're using really outdated technology? So can we talk a little bit about some of the challenges your courts are experiencing around dated technology? Judge Alvord, we'll start with you. Sorry, okay. I forgot to give the cue.
Waiting to be invited. So for me, there are really two, there are probably more than two, but two critical infrastructure pieces that you have to have in place to manage remote hearings and to have the flexibility to be able to do that. And one is a video conferencing platform of some kind, and the other is some way to manage the evidence. Because mailing evidence binders in to us, we actually tried this for a week or two. People would send their evidence binders to us, and then we're shipping them out again to the judges who are working from home. And that's not sustainable. So we moved pretty quickly to a way of managing the evidence that people are going to submit at hearing in a digital format. And so I think those two things are really key. There's probably more things, like good communication to the community and, you know, having good orders in place about when you submit your evidence and how you submit it and what the expectations are. But to me, those are the two key things.
Great, thanks. Judge Abrams, anything to add?
Well, I want to quote, and some of you in this room may remember Tom Clark. He was the director of technology for the National Center for State Courts for many years. Bright guy, gifted guy, recently retired. And the one quote, or I should say the most quotable thing I ever heard him say was, we in the courts are probably the best thing we do when it comes to technology is bring you yesterday's technology tomorrow. That's typically where we are. And what we've learned through this process of coming up with remote hearings and protocols for access to justice in such a short period of time is, in the greater scheme of things, if you look at the history of how we've operated courts, especially state courts, in the United States for as many years as all of us have had states and units of government that have been operating courts, that truly, and again, I'm going to digress, in Minnesota, okay, superlatives get you fined, hyperbole gets you jailed, okay? But when I talk about things that in truly almost in terms that are hyperbole, the greatest change that we will likely ever see is what we saw over the course of the last 18 months. The fact that we can go from where we were to where we are now and accept it as being a part of how we're going to do business going into the future. So I just point that out and looking for many, many years and many, many different ways to try and get this type of change, to open the thinking, to having people willing to change culture. Just like the first speaker we had this morning. I mean, what are people, hardwired to be afraid of is change. And we've come a long ways from that. So getting the tools together to implement some of this stuff, it was a little bit extemporaneous. I mean, truly at first. I mean, I was on a committee, we were looking at platforms, are we going to use WebEx? Are we going to use Microsoft Teams? Are we going to use Zoom? Maybe Zoom isn't the best, but everybody can get access. I mean, boom, boom, boom. The decisions start getting made serially to allow us to get to a place where we can provide this sort of substitute for bringing everybody back in person. But truly, as my learned colleague Judge Alvard has pointed out, is that we're trying to deal with things in the same way. Like a few weeks after we started doing these hearings, I had this order. I wanted to get it down to like one page, 5 or 6 paragraphs. What do you do with paper? What do you do with exhibits? How do you get them submitted? I thought if it were short enough, counsel and litigants would read it. That's always been wishful thinking. That's never been fulfilled. But some people did, some people didn't. But it was still kind of this cumbersome process that we have going on. But by the way, if you get people to do it, it's not bad. It's just not great, and there's not a lot of uniformity. And it also leaves leaves you in the lurch when things come up outside the plan. That is something new that wasn't submitted in advance. I always needed 2 weeks. I still need 2 weeks because we still do it the old-fashioned way. Everything that comes in, huge amount of labor, gets scanned and it gets put in a pre-hearing file in Odyssey under the case heading, so we know that we can just bring it back. But again, it's rolling with what you got.
Yep. And I hope that you've all taken a few minutes. I think about what you just said in the very beginning, which was everybody turned really quickly to address this pandemic and figure out how to support remote operations. So I hope you've taken a minute to congratulate yourself and your staff. What a big change you all just did to the U.S. court system and international court systems. Court systems around the globe certainly have changed, on a dime to support operations. But as a technologist in the court industry space, and Joe Wheeler, I'm sure will appreciate this, we were fascinated at how quickly and how adept you all were at implementing some different solutions. So, I think this summarizes it really well. Courts have become extremely resourceful. Congratulations in finding new ways of working. Who would have thought? The goal is, let's take some of those great ideas now that you've implemented and turn them into long-term solutions that can really support your operations and help you to continue to provide service to your constituents, because courts, as they were formerly defined, have a new definition. So let's talk about the future. Let's look to that a little bit and talk about what are some best practices, or how are we transitioning to this new state of the future of courts. So I want to dive a little bit more into that. So Judge Alvord, why don't you share some of your ideas of the long term? You talked about a 5-year plan that you started, a year ago that you've now expedited to implement more quickly. What is your experience now led you to believe is truly possible in your court system?
Yeah, we had a lot of skepticism about remote hearings to start, both from my own colleagues, because we have to make credibility findings, and how are you going to judge somebody's credibility when they're either on the phone or they're on a video conference? But we found that it actually works pretty well, at least from our point of view, and I think the lawyers that have attended our hearings have also agreed with that. So that was a nice finding. In my office, we built new hearing rooms in 4 of our 5 offices, and we planned them. We said, we're going to build hearing rooms of the future. And it turns out what we built was the hearing rooms of the present 2 years ago. So what we left out of these great hearing rooms, they're nice. They've got screens on the walls, and lawyers can sit down at the table and plug into a thing, and they can put their stuff up on the screen, and lots of nice little bells and whistles. But what we left out was video conferencing capability. And so if we're going to do a hearing where some people are warm bodies in the room and some people are two-dimensional bodies on a screen, how do we set up cameras to do that and capture all of the people in different places in the room? How do we set up microphones to capture that and screen out the noise when people are flipping their pages or coughing and doing those kind of things? So we haven't touched that technology, but that's one of the people are going to have this expectation that we're going to be able to provide a partially remote experience if necessary. So they've got a witness, they don't want to make them travel to our hearings, so can we have them appear remotely? And we are going to be expected to have the backbone in place to do that. We've got our digital evidence platform, which we knew when we started that we're going to want it to stick around. It was not going to be just for our remote hearings, but we want to use it in our live hearings as well. But how do we outfit our hearing rooms in a way so that people don't have to bring their evidence binders into the room, that they can access? We can set up the judge with a computer in front of him or her, and they can access the digital evidence on a screen. But how do we do that for the witness? And for the self-represented, we have a lot of self-represented folks. Do we have to provide them with tablets? So those are the struggles that we're going through right now. How are we going to scale this digital evidence platform so people don't have to bring binders in? I don't want to ever touch an evidence binder again. But I know that I'm in the minority in that.
Just by a show of hands, is everybody sort of struggling with the same sort of kind of challenges? How do you deal with evidence? How do you deal with, removing the barriers for all of the parties in a case? Is this a common thing that you're seeing? Got some head nodding a little bit. Yeah. Okay. Judge Abrams, anything that you want to add in terms of?
Well, I'm going to go back to the original point about fairness, and we have discovered very quickly as part of the process, of course, that sometimes there are just things that people, and I call them pro se's, I don't call them self-represented, because usually if somebody doesn't have anybody in their corner, they're on their own, and I'm not going to debate that point too deeply, but my point is there's a lot of case types where there is something that's pivotally important. I can think of many remote orders for protection hearings, for example, where people have pictures of physical injury, and they've got them. Sometimes it's just on their phone. Sometimes in traffic cases, you'll see, oh, geez, the sign was completely obscured by vegetation. They've got a picture. It's the type of stuff that we just, it's almost like, I guess the Latin is ad passum. We just go right by it. We wouldn't think it's a big deal because if somebody was in the room, they would hand it to us, and it would be tangible, and it would become part of the record very, very quickly. So in terms of just some of the general challenges, that's something we face every day. And for us to be complete and have a system that's robust, that we can rely on, that people can walk away and say, geez, they considered absolutely everything, it's got to be there. Now, the other aspect, and we haven't talked about it, is I'm guessing most of you in most of your jurisdiction have some type of court administrative process for the receipt and handling of exhibits, both for purposes of recognizing them, making them part of the record, and preserving them for whatever purpose you've got going on. And that's become a lot more challenging as well, because we get a lot of this like extemporaneous stuff out of the blue. You know, we've always had the stuff off the cell phone, but you get everybody in the same room and you can deal with it. But when you've got people in different places, it's much harder to deal with that. And so we're at the point now where having something in place would be a really useful thing.
And I've moved this because you've now talked about cell phones a couple of times, and I wanted to be sure that we addressed this maybe fear. If we implement technology in my courtroom, can everyone play along? Will everybody be able to use the technology that we're implementing? And so I love the statistics, Judge Abram, that you've provided for us about smartphone adoption in the universe.
Well,
Why don't you talk about? Go ahead.
I get a chance. I love to use big words, right? I mean, what judge doesn't? But I don't get a chance to say ubiquity very often. But this slide represents ubiquity. That in both the developing world, and there's some further statistics you can break down, but you can kind of count on, like right now in the developed world, in our world, about 3 out of 4 people have got a smartphone. And nearly everyone has access to some version of a cell phone. In the developing world, the numbers are less than that, but surprisingly, not significantly less than that. Nearly everybody has got access, because, you know, in the developing world, cell phones quickly became much easier once they proliferated to have folks have than hardwired, whatever, the traditional landlines and stuff. But the point is, and we talk about staying power, because one of the reasons why courts have been slow to adopt technology historically is everybody's afraid of making the wrong decision, or you're stuck in that kind of quagmire of you know, what's the best, and everybody's got an opinion, and nobody's opinion is of any less value than anybody else's, and it slows down the process. But this notion about the persistence of remote access is going to follow this type of statistic, which is that if everybody's got it, it's not a wrong move to make. And I think most of us have realized that not that long ago, that when we switched to a remote environment, that people like it. There's an expression we used to use sometimes back in the day on dealing with class action settlements. You know, what is the capture rate? How many people are going for it? And it seems like in connection with remote access to court through smartphones, everybody.
And an expectation. I mean, we do everything now on our smartphone. So the fact that I can be able to have a court appearance or talk to the judge and talk to my attorney, I think through my cell phone is what my expectation and my children's expectation would be in today's kind of modern workforce. So I think that's a really good reminder and helps address his fears about what is that common platform to be able to provide service to my court. So let's look at some of the technologies. We talked about smartphone, and you know that's a fundamental piece of this story. But Judge Alvord, you talked about some evidence or the process of managing evidence and trial folders and you know, trying to minimize the amount of paper and the process tied to trial notebooks. So I want to talk a little bit about some of the coping mechanisms that have been implemented in courts during the pandemic or as a result of the pandemic to try to deal with evidence as they were being presented to the court. So I think in most U.S. court jurisdictions, the rules of procedure require that evidence be presented to a judge to make a call about whether or not it goes into the record. So unlike electronic filing, there's a workflow that happens around evidence where a judge really reviews that and makes the decision about whether that's going to be accepted into the record. So I think that procedural nuance introduced a new layer of complication to this digital or digitization of courts. Many courts have had e-filing now for a really long time. That was one of the early technology adoptions that went out there, but evidence added a new wrinkle. So we saw a number of coping mechanisms that came into courts as a result of handling evidence. We've seen Dropbox used as a temporary measure where files would be uploaded to a Dropbox location. presented on a thumb drive. So you'd send a thumb drive down to the clerk's office, trying to email some of those directly to a court administrator or to a court clerk to be submitted for today's hearing. So there's been a number of what we refer to as coping mechanisms. One of those is also a screen share. We see a lot of screen share that's happening in the Zoom and Teams environment now that we're in. But it's interesting if you think about what happens with screen share at the end of a session. If I'm presenting my evidence to a judge on a screen share and I turn off my screen share, that evidence is now in my possession and not in the court's possession. So there's a little bit of a security and who really has care, custody, and control over evidence in a screen share scenario. So I'm just wondering, are those some of the coping mechanisms that, as you were starting to implement a digital process, that you were seeing?
Right. So we had e-filing, but our e-filing system had an upload limit. So people ended up having to break their 500-page exhibit down into 2 or 3 or 4 different chunks and then file each one of those chunks separately. And then they went into our case management system. Yep. And then we had to manually pull them out of the case management system and put them back together again to make the one exhibit. So it was very labor intensive. And you're talking about that's one exhibit, and we had 20 or 30 exhibits. We had to do the same thing with it. So we trained our judge before we had the digital evidence system. That was our digital evidence system. Send us PDFs, we'll put them together, and we will make ourselves an evidence binder that we can work with during the hearing. And we were stamping it in Acrobat with a little exhibit stamp and creating a sort of a final product that we were then storing with the case. But it was a lot of work. I was spending a couple hours before a hearing just putting together the evidence and assembling it in a way that I could make sense out of it, because the parties were not giving us a package that they could present, that they wanted to. If I'm a trial lawyer, I want to control how the judge sees my evidence. But we didn't allow them to do that because they had to break their stuff up into chunks in order to file it with us, and then we had to go through the clunky process of putting it all back
And suddenly
together.
you're making the determination about how you want to interpret the evidence that's being presented. I think I'll put that here.
Yeah. So, and we're still doing that with some of our cases. We haven't made the transition completely, but the nice thing about the digital evidence platform that we use is that the parties can decide how to upload the evidence. They do it. We don't have to touch it. They put it in the system, and then most of the time they get it right, and they don't give us a mess that we have to deal with. Once in a while we get a mess, but the parties upload their evidence, and then it's there, and it can't be messed with. They can't make changes to it. They can't manipulate the documents. And then so everybody goes into that evidence platform, and if you want to print something out, you can pull it out and print it. But you've got your evidence binder sort of built into the platform.
Right. Judge Abrams, any coping mechanisms that you had seen implemented that were great temporary measures, but things that presented particular challenges to you?
Well, as I mentioned earlier, one of the things that we did, or I did, was send out an order for all the civil cases. I was just doing civil to make sure that things got submitted a couple weeks in advance, so we could go through this very, very labor-intensive process, because sometimes it was hundreds and hundreds of pages being scanned as a file and stored as a preliminary exhibit before we could actually deal with them. And for a lot of staff, that was taking up a lot of time, if you can imagine. I mean, you get stuff in binders, you gotta, take them apart, scan them, you've gotta provisionally put something on them, and then just have them there ready and waiting. So you know how it goes, some cases settle, sometimes things get continued, et cetera, et cetera. There's a lot of labor that went into the process. We still don't have a digital evidence platform in my jurisdiction. We're certainly working on it, but the point I get to is that if you don't have something that's in place, you're doing a lot of the stuff that you used to do and fume about in person. You're now doing it and fuming about it remotely. And when you talk about the frustration factor, I think there's like a multiplier. It's like a diving competition, when the, whatever that is, times whatever the judges scored, because it makes things tough. It doesn't make things impossible. And frankly, if people follow my order, it's not terrible, but it's rare that they follow it, and it's really good.
Right.
I'm so encouraged to hear that I'm not the only one who issues orders that people don't read. So it's nice to hear that from a judge in another
It's
state.
everywhere.
Yeah, you're welcome, yeah.
Yeah, thank you.
Well, so, this is the time when we want to talk about the platform that Thomson Reuters, has, delivers to address these specific coping mechanisms and makes a long-term and really robust, more scalable solution. So when you go to the exhibit hall, you'll be able to see a demonstration of a product called Case Lines. It has been implemented in a number of jurisdictions across the U.S. and internationally, and really what it takes is that very lowest common denominator, ease of access way for parties to digitally submit the evidence to a court so that a judge and even opposing counsel can review the evidence, mark it up, have it in a highly organized and annotative fashion, and then the judge can move that into the case management system as part of the official record. So what's really, this platform's facilitating is not just a solution in remote hearings. If you think about court proceedings, there's a number of ways that proceedings can be really moved forward. Oftentimes the parties need to be in person. Sometimes some of them can be appearing remote, but in most instances, especially going forward, what we're really seeing is this hybrid scenario where some of the proceeding is in person with a judge behind the bench, one of the parties is potentially in the courtroom, and another party and witnesses and even jurors are coming in remotely. So what you need in order to facilitate that court operation into the future is a platform that supports this hybrid notion of parties being able to participate in a matter regardless of their physical location at a time. So with the Case Lines platform, you're able to, again, digitally and securely present information. The judge can then make decisions around that information, and it's highly secure and highly organized so that the parties are always looking at the same piece of evidence at the same time. Now, Judge Alvord, you're using Case Lines in your court now.
We are.
So why don't you share, a little bit about your experiences both in the implementation of that and then in the adoption of it by the parties?
So we've done kind of a phased implementation, so we're not 100% implemented yet. We're about 60%, I think, for our total organizers, maybe 70% implemented in our cases. 100% of my cases are using Case Lines.
Mm-hmm.
So training the judges, it's a process of exposing them to it and then giving them a chance to practice. We developed practice cases. We broke our judges up into teams of 4 or 5, and they each got a practice case with a bunch of evidence in it. Go in, and we have them go in and do a mock hearing and play with the evidence and practice doing the annotations and stamping and all those things. Mm-hmm. So that's kind of how we did the rollout. The judges, for the most part, like it. I think the attorneys like it. I love, one of the things I like the most about it is that it's the way it handles multimedia evidence, because every time somebody had a video or audio recording that they wanted to submit to us, we had to come up with a way to manage it. We put it on a flash drive or give it to us on a CD, and we've got to have a screen in the room where people can watch it, and it was always a mess because we didn't have a consistent process. Mm-hmm. So now people can just upload that evidence in any digital platform, any video or audio platform that they use, and we could play it right there on the screen. Mm-hmm. And it's really handy because we eliminate all that special handling.
Have you found that it's on kind of the same level as when you were getting, trial binders or evidence binders in paper form, or what's been your experience in the usability of digital versus traditional means?
So I think people still want to print out certain documents that require heavy consumption. I call it, with judges, you got to read it, you got to understand it. Mm-hmm. And so for the documents that require like maybe an expert report or a medical report or something like that that requires a lot of heavy analysis, I think we're still printing out to have something in our hands. But our folks are learning to process most of this stuff digitally. There's a note-taking system within Case Lines, so you can tag your notes to a specific page. So I can just make notes, and then that gives you a hyperlink back to that page. So it's like putting Post-its on the binder, and it works actually faster than Post-its, and you can color code them, and there's all kinds of fun things you can do with them. Come up with issue tags, so you can organize your notes around issues or around a party's presentation or something like that.
But you were able to develop kind of processes and procedures to support the use of the platform in some way that
Yes.
made sense to your judges. Yeah.
Yep.
Okay. Okay. Well, Judge Abrams, as you're thinking about, this type of, how to handle digital evidence, what is some long-term solutions? What would be some maybe best practices or some advice you would give to court administrators as they're thinking about, okay, we want to solve this challenge for the long term going forward? What are some things that come to your mind?
Well, yeah, it's like most other things. To be effective, you need to have a plan. And the plan is to figure out how to sort of merge the various, whether it's your court administrative process for the collection, the storage, utilization, retention, transmission of stuff, along with, how it's going to come in. Like I say, I'm endorsing a concept. There are, as we move more and more into this electronic realm, there are means by which you can do a lot of this stuff electronically. But we're still stuck with this notion, and I don't know why. It's maybe because of our education and training. We just can't seem to get out of our own way sometimes. Sometimes we like to have stuff that's tangible just because. I'll give you what's a very, very interesting sort of phenomenon is that people like certain types of documents to look at. If you want to see did somebody sign the document, I don't know why it is. It's almost ghoulish sometimes. It's like looking at a car crash. You got to see the signature. You're not going to believe it unless you do it. I mean, I don't want to avoid the response in any way, but we have to sort of channel all these thoughts we have and all these expectations we have to make sure that they're going to work in the environment that we have. Some of these things that you talk about, though, pose real challenges where we've got especially the hybrid type approach where you've got to be able to show that to somebody who's both here and elsewhere. And that's why I say you've got to have a plan. You've got to have a way to approach it. Now, screen sharing has been the sort of universal sort of means by which most folks are getting to that, but it still doesn't take care of the long-term needs that people have. So
the record.
The record. Well, yeah, and the record is a big thing. And I'll take you way back. I mean, and I know we've got just 1 minute here, but I'm not going to force a show of hands because that would instantly make you all old beyond your years. But we many years ago, when I say many years ago, about 15 years ago, we had a housing collapse. If you can imagine, housing prices plummeted. I mean, fell through the basement. Maybe a lot of people today can't remember that time. We had a bunch of cases that came up where people were challenging their foreclosure, saying you couldn't come up with the paper, the mortgage, the note. And it's because there was the mortgage electronic registration system, MERS, that they separated the mortgage from the servicing, sold the servicing to companies to service the mortgage, and then sold the debt to like Goldman Sachs to syndicate as a security. So, you could buy some share of a mortgage pool. But when it came to the point when nobody was paying their mortgage because nobody could afford their home, everybody was coming to court. And I'm telling you, in the heyday, I was doing along with all the other business I had going on, I was assigned 15 foreclosures a week. I mean, back in the day, that went on for probably about a year. And it was like out of grapes of wrath how sad these situations were. It was just, people on their knees and screaming and pleading and crying. And so sometimes they got a lawyer and said, show me the paper. And that was one of those weird sort of things. And we had just converted to an electronic filing system, too, which made it even harder because sometimes people actually had the original, but it was only scanned in, in the very early stages of that. So what I'm just saying about having a plan, it's a plan that's at a high enough level and deep enough thinking that allows all these sorts of things to somehow be merged effectively. And what it ended up being in that particular situation, it ended up just being decisions that if you can establish you gave them the money and they didn't pay, it's probably yours to take back. And that's kind of how that unhappy story ended. But up until the law, that time, the law changed. And not for the least of reasons is because sometimes people couldn't produce the original, and the law had to change to accommodate where society was. And I want to get back to maybe answering your question, because I sometimes go in a long circle, but I'm going to do it. That's one of the things one of the challenges we all face. I don't know if anybody is here from New York, but are you? Yeah, so you know what I'm talking about. Every one of your court rules is like statutory. Try and move a comma, it'll take 5 years. Try and insert a semicolon, probably take 7 or 10. I mean, that was my experience in dealing with civil justice reform and trying to change how things work. But for places where you've got the ability, where you've got the ability with the court rules and how you operate, and these things tend to intersect between substantive rules and administrative processes, is where you've got the ability to look at it. And that's why I say you need a plan. You have to look at it comprehensively. And you can get the kind of support you need from people on rules committees, people in judicial councils and things like that. But in some places, it takes that in order to achieve and accommodate these sorts of changes that are going on. And this, going back to where we started this whole presentation, this area of how we're going to change the way evidence is received and handled and stored and maintained and utilized for basing decisions, this in fact will change, just because everybody's now very much devoted to changing the overall process and how cases get presented and where they get presented. So it's going to happen. It's just got to be comprehensive.
Yeah, I think what stood in the way prior to all of this is a fear of making changes that might ultimately impact the appellate record or impact just the procedure itself. But we had a microcosm like moment of, we can do this, we just did. And we showed that there's tremendous benefit to digital modernization of how you handle cases. So don't be afraid to now make that a long-term initiative or a long-term policy change in your courts, because there are a lot of benefits. So in the last few minutes, let's talk through those, and then we'll open up to some Q&A from both our in real life and in our virtual attendees today. Because there are a lot of benefits. And first and foremost, there's an immediate benefit that we're seeing through our Digital Evidence Center as a means to conduct hearings on the number of hearings. So if you think back to that National Center study that said the number one reason for backlogs is the amount of continuances and delays in hearings. Well, what we're now seeing is by using this type of platform, courts are reporting 50% fewer hearings and cases. Now, if that doesn't hit your backlog, problem kind of square in the head, I don't know what will. If you can just get the parties to come around their case, to talk to the judge, to talk to their attorneys, and move that proceeding forward in a digital notion, now you're really starting to make an impact against those backlogs. So there's operational and judicial benefits. So Judge Alvord, having firsthand knowledge now of the impact of the platform and handling digital evidence in a new way, why don't you share, again, some of the benefits that you've recognized?
Yeah, I think it's leveled the playing field for the self-represented community and the attorney community. People were concerned at first that the lawyers were going to be so much better at managing the upload and all of the stuff that has to go on in order to get your case evidence into the case line system. But we found that regular folks can figure it out. And
because they're really good on a cell phone.
They can upload from their cell phones. And if they forget a document, we have the ability to send them a quick link that they can just upload directly from their phones. They say, oh, I've got that document, it's here on my phone, and they can send it to the system within a couple of minutes. So we're receiving evidence on the fly. And so one of the problems we always had with continuances was that people didn't come to court with all of their evidence. And they said, oh, I've got this document at home, but I forgot to bring it. And then we had to either keep the record open to allow them to submit the document and then give the other side a chance to respond to it, or we had to continue the hearing. But now it's like, well, give it to me now. Come on. I'm ready to receive it.
Right.
Send it in.
So it's like no excuses. There's
Right.
not that
That's
reason
right.
to say, oh, my dog ate it.
Right. Yeah, so I think it really has leveled the playing field. Sometimes I get a case where we get evidence. So in our cases, there's one side is the government, and the other side is usually a citizen or a business. And so we get, the government evidence comes in, we get nothing from the other side, and then I get them in the hearing, and I say, okay, I see you have not submitted any evidence. Is there anything that you want to submit? Did you have trouble submitting the evidence? Did you skip a step? Can I help you right now get your evidence in? And sometimes people have things that they want to submit, and we take care of it right away. And sometimes they just say, no, I don't really have any evidence. I just want to give my testimony.
Have you seen any direct correlation to case processing times? I know you don't have a ton of backlog. We were talking about that earlier.
Right,
But what about just case processing overall?
So the time that we're spending managing the evidence before the hearing has been reduced a lot.
You're not having to do it.
I don't have to do it. I'm still going through the evidence, but I don't have to spend nearly as much time before the hearing trying to organize it and understand it. So in our administrative cases, in probably 80% of our cases, we package the evidence together and we give it to another government agency when we're done. We give them our decision and the evidence, and then they have a reviewing process that they do, an administrative review. And so we're hooking up so that they can get the evidence straight out of our system. We used to have to print that stuff out, put it in an envelope, mail it to the agency so that they sometimes would lose it. But now we're giving them a link, and they can go in and they can just pull the evidence right out. And I envision someday the reviewing court will do the same thing. We'll be able to provide the official record to a reviewing court in a digital transfer process rather than, again, having to print it out and then they take it down the street and then they file something with the reviewing court.
Okay. Judge Abrams, I'm wondering from your perspective, how do you see all of these different kind of new digital ways of operating for the parties? Do you see that leveling the playing field? Do you see that increasing fairness and access?
Well, this is kind of where I get on my soapbox, because when I talk about fairness, it really has come to pass that we all know that in certain situations, people are either not going to afford lawyers or just in any circumstance to get lawyers. And they're the things that have got great impacts on people's lives, whether it's landlord-tenant or whether it's some version of domestic abuse or domestic violence, whether it's some version of their inability to pay things or whatever, consumer debt. That we have changed how people approach things. That is, we have now got more engagement. We have got more access. You know better than I do in your jurisdictions where the rate is going up for participation in remote hearings over what you had before. But when even fewer people showed up to court, they had a chance maybe to pull something off their phone or show something or bring a photocopy of something to someone. So I just think this whole process is being essential as we shift to this, and especially among those communities of participants in courts who haven't otherwise got a way to get the kind of help that they need. In other words, it shouldn't be any harder to do this than it would be if they showed up in person. And in fact, if you can make it easier, that would certainly be better.
Right. Especially in the self-represented scenario, to not have to rely on an attorney to present my information. I can do it from my cell phone. Really just, if I was self-represented, I feel like it would be a more pleasant experience. I wouldn't be as stressed as a self-represented litigant of the proceeding itself, and I would have an overall better experience, I think, with my court. And at the end of the day, maybe increasing morale and the experience with the court is a goal that our court should also have. No one wants to be in court, so how can we make that experience more efficient and better for all parties involved? So let's just transition to some final thoughts and recommendations as you all, go back to your jurisdictions and you think about, what's the next step that I want to implement in our modernization efforts. We've had some great results through some coping mechanisms throughout the pandemic, but how do I really take some things forward? I've got a couple notes out here, and some of these themes have come through already. Really good planning on my part. We've talked about, in your planning perspective, what cases might make more sense, and what scenarios does it make sense to have digital solutions. And I think the really important message is here that there isn't really a one-size-fits-all approach. digitization and modernization means having the flexibility to have a variety of approaches to fit the scenario and to fit the litigant's needs the best way, even in an individual case. Would you do you want to expand upon that, how you arrive at kind of which cases?
So one of the ways that we decided early on which cases to assign to a digital platform versus not was the size of the case, the amount of time that was scheduled for the hearing. If it was a 5-day hearing or 3 or 4-day hearing, we would generally, those longer cases would get assigned to the digital platform because we assumed there'd be more evidence. I'm not sure that was the best way to do it, but it was the only way we could think of at the time.
It was the only way, yeah.
My view is just do it with all the cases. There's no reason not to. I think you have to figure out when to invoke the digital platform. When do you open the case in the system, and when do you notify the parties and all that stuff? There's some process issues there, because if a certain number of your cases are going to fall off the calendar at some point in time, you don't want to send out all those notices in every case. You might want to wait a little bit and see which cases are surviving on the calendar at a certain point in time before you start sending all those notices out.
Which is a really good point, that collaboration between the bench, between administration, between the bar. I think that's implementing any digital solution or any modernization effort, that collaboration is really key in that buy-in. And the last thing that I'll point to, and then we'll open it up for your questions for the panel, is that I think, remember that there's new and evolving skill sets now that are being introduced to the equation. So you might implement all kinds of technology in your courthouse, but if you don't have a plan of how to run that technology and really how to implement or incorporate it into your daily workflows, then the technology suddenly isn't helping at all. In fact, it's getting in the way. And you both had some I think, great stories to tell about we don't have the video piece, or the microphone rattles so much when they talk that now the court reporter can't hear. So technology, sometimes it's a great thing, but you've also got to have a plan of how to use that technology, and that involves an evolving skill set. So remember that with your staff planning also, as there's maybe roles of technologists and others, or courtroom producers that we were talking about, that really become part of your budget and part of the equation. But with that, why don't we open it up to some questions from our live audience. I forgot to open up this whole thing with, I'm here live, I'm not a cat. I don't know, did anybody have that in any session? I can't believe I didn't remember that. Anyone have any questions for our panel today around transformation? Yes.
I think around the evidence.
I might need to hand you a microphone, just so we can make sure that the people in the virtual world can hear. Test. Yes.
Thank you. I'm Deborah DeBerry from DeKalb County, Georgia, the Clerk of Superior Court there. And we ran into the same issue around evidence in terms of upload size for envelope or e-file. And so we used email. And so I was curious to hear, how did you, but there is the same issue that you experienced with the having to put them together. And what we used was the parties that was submitting the attachments, exhibits, whatever it may be, in paper form would send it to the judge, and the judge could piece it together. So is that what this system does? It pieces that together? Is that what you used?
So,
And then would file what they wanted, what was accepted.
right, so the parties have to name the files the way that they want them to appear in the system, and once they do that, they can upload in bulk and sort them in the way so that they appear in the record in the order that they want, so you don't have, Exhibit D first and then Exhibit W.
It's presented
But-
just as the party wants the judge to be reviewing the evidence. So they put it into their own organizational structure. They can tag that with notes. They can tag it with information that directs the judge to a particular minute in a video or to a particular piece of a photo evidence. So it really gives the power to the presenting party, the organizational way that they want the judge to review the evidence, and takes the burden off of the judge from saying, okay, here's all this stuff, how do I organize it into how the party might have wanted me to interpret that? So it really mirrors the paper process, all digitally through a secure platform.
Why wouldn't the defendant or the party submit it the way they wanted it presented?
They do. I mean, that's the point. Yeah, that they can.
Yeah, they log in and they upload the files and mark them, and then they release them to the judge to see.
What is the difference in that, though? I'm just trying to see if there's a benefit, because if they emailed it in the order that they wanted, that can be uploaded to the case management system and be filed that way, where there are no size limits.
Right, size limitation. And also, if you email a video file, the recipient of, let's say, body cam video
Correct.
footage, the recipient has to have that technology on their end. So through a digital evidence platform like Case Lines, you're removing that need for the receiving party to have the same technology on each computer that's reviewing that. So we facilitate that just through the technology, through
Got it.
how the technology works, so that the end user, consumer, isn't required to have the same body cam video technology on theirs.
True. No one's going to accept DVD or flash drives.
Yeah.
We're just not going to
Well, and
introduce
how
it
do you,
into our system.
yeah, how do you authenticate the integrity
Correct.
of each DVD version? And now I got mine and it's broken and I don't have the right player, and what's a DVD?
Right.
So you've got that too.
Well,
Thank you.
so we skipped over email completely, except in sort of emergency situations, but email's not secure. So if you're asking people to email, medical records or any kind of financial information, you're really kind of violating the info security laws, HIPAA and FERPA and all the IRPAs. And so we skipped email completely. Our e-filing system is secure, so it's secure in transit. But it was nice because we handed control of organization of the documents over to the parties where it should be.
Back to the parties. That was a great question. Thank you.
Hi there. I was wondering if you could
Oh,
address.
Kevin, you may need to turn that on. Yeah.
Technology.
We have no technology person.
I think it's on.
Are we on now?
You are.
There we go. All right. I'm Kevin Bowling from Michigan, and I'm just curious, as you moved to Case Lines or looked at this technology, did you run into any problems in your jurisdictions with needing to change rules of evidence or court rules or other things to allow for this? Were there any problems with the best evidence rule if you're going to digital? And I'm curious, on cases that you may have had that had to go up for appellate review, what do you do if your Court of Appeals can't accept the evidence in the form that you're using it in? Do you have to, go from, tangible copies to digital and then have to transfer it back to go to the Court of Appeals? Or how did that part work out for you?
So we didn't run into any problems with rules of evidence. We were already dealing with a lot of electronically filed documents, so they're copies of copies. And so it wasn't, that wasn't an issue for us. I don't think any of our cases have made it to appeal yet, so I don't know how that's gonna,
Yeah.
2 years from now, we'll know.
You must be doing everything right then.
No, that's not it. But it just takes a few years for a case to get up to appeal and then come back to us. So
Well, the
we'll find
platform
out.
certainly has, so it has been used, for instance, in the UK for 10 years now, 5 years now. And so that threading, that passing between lower courts to appellate courts, there's multiple ways that the platform can support that. At the easiest, the lowest level, is that the appellate court judges and clerks can be added into the electronic bundle as it was maintained in the lower court. So that eliminates the need of having to take this huge set of information and reproduce that and then somehow send that in paper to the appellate court. Instead, you're inviting those now appellate reviewers to be participants in the bundle itself. So that really facilitates the easiest and fastest way. There's also then built into the platform ways to export all of the admitted evidence bundled. They are bait stamped, they are formatted in a way then that they can be put into a case management system and then ultimately transferred with the record as that goes up. So there's many ways built within the platform to do the transfer of the record, but at the easiest way, what we see right now in a lot of places is just inviting the appellate users, the courts and clerks, into the bundle as it exists in the trial court.
And then they can download it. You can down if you don't want to deal with it on the screen, you can download the bundle and you get a nice tight PDF document that is bookmarked with each exhibit. So you can actually navigate the PDF document pretty easily as well, even if it's 2,000 pages, because it comes out in an organized fashion.
All right. So just one follow-up. If you're looking at criminal cases in particular, is there any benefit to trying to get a sheriff department or law enforcement agency and a prosecutor's office to buy into case lines too?
Oh, 100%.
So that
Right.
everything just moves and transfers
The
more
ecosystem.
seamlessly?
Mhm.
Yes.
That's right, because the more you can eliminate in that transition, right, you eliminate those points of failure in the process.
So it's not just for courts?
It is not just for courts. It is a open platform for all parties that need to submit documents or digital evidence of any sort, whether it's law enforcement, DA, prosecutor, judges, attorneys, self-represented, witnesses, jurors, anyone that needs to interact with it. There's a view into the information.
Thank you.
Yep, thanks, Kevin. Congratulations. Other questions from in real life? Yes.
Oh, no.
That's your department, real life.
Okay. When you say that you would upload it and then you would download it and put it in the case management, is that electronic, or are you printing and then putting it in the case management system?
As a technologist, I love electronic. At the end of the day, it can be printed. So
Yeah.
it really is just dependent on your court.
Okay, so upload electronically, move into the case management system, because that would remove a lot of the, I don't know, that paper.
Yes, yes. And so it's, there's also ways to integrate that, to make that experience automated through an API exchange of the information. So there's a million different ways that the information can be then put into the case management system manually, with paper, through an electronic, like an API, a data exchange of some sort, or the download, log into your case management system and upload it again. So there's a multitude of ways that you can transfer it into your case management system.
Can I just mention one of the regrets that I have about how we
No regrets.
how we implemented? No, one of the regrets that I have, I told David about this. We were in such a hurry to get a digital evidence platform when COVID hit. I think we broke a record. We did a procurement in about 6 weeks, which is unheard of in government technology procurement. I don't know how we did it. But one of the decisions that we made early on was not to integrate the case lines evidence system with our case management system, because we felt like that would take too long to do that. And the benefits we would get from it, we thought, were not that great. So our evidence system stands alone. And so for us to download, if we want to put that evidence into our case management system, you have to download it, comes as a PDF, and then you have to upload it to the case management system. If you integrate if I could go back and do it over again, we might have taken a little more time, spent a little bit more money, and got an integration between our case management system and the evidence system, and then we'd be able to open a case from the case management system, just push a button, and a lot of the data that's in the case management system would transfer over into the case, so case name, case number, those kind of things, and then also the transfer back of the evidence when it's done. That would have been a nice convenience to have.
I think it's oh, go ahead.
We have Odyssey as our case management, and our entire court system is on the Odyssey. I provided it for every agency and every court, and everyone's using it. So has Tyler written an interface for Caseline to Odyssey?
You want me to take
Do you
that?
want to take that, Brendan?
Yeah.
Sure.
The state of New Hampshire has just completed their integration with Odyssey. So it's going to actually going live very soon. So I can give you the contact information of the people there that put that together. But
Happens once,
correct. Yeah,
then we'll all benefit.
right.
And I want to go back and we've got 1 minute, and then actually time's up. I want to go back one more just point, launching off of yours. The beauty of this type of platform is the simplicity of implementation. You can have a solution to handling digital evidence in days. Now, for those of you who are starting a case management procurement, you know that an implementation of a case management system takes a long time. But you can really look at this platform as a phase one of your digital evolution for your court. It can really be implemented in a matter of days instead of, years and months. Thank you all for your time. Thank you to our panel. I hope that we've provided some nuggets of information that you can take back to your courts as you think about your modernization efforts. Come see Caselines at our booth on Wednesday. Everyone have a great conference. Enjoy the weather. Yay.
Thank you.